Good morning, Your Honor. It's not a good morning. No. You are using my name on an occupational license and you're not in compliance with what you're supposed to be doing. It's unacceptable. If I find that it happens again, I'm going to yank it. I want to make sure that you're not using while my name is on the license. Do you understand?
Yes,
I'm sending you now for a drug test. I want to make sure that you're not using, and then if I don't know what I'm going to do. The first thing I want to send you for a drug test to make sure, and then we'll go from there. So we'll send you and then we'll have you come back.
Yes, sir.
This is who, Judge?
No, don't worry about it. I'll have
Okay,
tutorial.
thank you.
More Mr. Rios, more. So you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Your Honor. On February 20th, 2025, officers were dispatched regarding a DWI at the 14,700 block of Wallaceville Drive in Harris County, Texas. The officer observed the black Dodge Charger parked at an intersection when the light was green for motor vehicles to proceed forward. The officer utilized his horn to get the driver's attention, but did not get a response. He then made contact with the defendant, who was the driver and sole occupant, and observed the defendant to be asleep while the motor vehicle was operational at the time of the offense while his foot was on the brake. The officers were able to open the motor vehicle through the front passenger door to turn off the car and observed red bloodshot eyes, slurred speech, a strong odor of alcoholic beverage, and chunks of vomit on the defendant's shirt.
Passed out at a green light with vomit on your shirt and still saying you didn't drink? That's not a DUI case. That's a courtroom slam dunk.
The defendant denied consuming any alcoholic beverages and stated that he was coming home from work. The SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walking turn, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results are a .140 and a .141. He was identified by his driver's license.
Got it. Any other prior DWIs and license?
No prior DWIs and his license is eligible.
Got it. All right, Mr. Rios, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming any, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Now, because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you, you pick up a new case. You're a danger to my community. I only have one place for you. Do you understand?
Yes, sir.
For now, I'll have you go to Victoria, sign a reset. We'll have you get with Fleischer for your bond conditions, and after that, you're free to go.
Thank you. I'm ready to sit there.
Yes, ma'am.
Caught on camera stuffing nearly $470 of Target goods in your purse. And now, the judge bans you from every Target. What would you do with that kind of restriction?
Ms. Torres Rodriguez, ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to be silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On Saturday, February 22nd, 2025, officers were dispatched to a theft call for service at the Target at 22165 FM 529 in Harris County, Texas. The LPO advised that the defendant was observed on video placing items in her shopping cart. She then went to a different aisle and began placing those items in her purse. The defendant then exited the store past all points of sale with those unpaid items inside of her purse. The reportee then escorted the defendant back into the store and had the defendant empty the stolen merchandise from her purse. The total value of the item stolen was $469.92.
Got it. Okay, Ms. Torres, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Target whatsoever for any reason. You understand? If I find that you go to a Target or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. You understand? You mind filing that? No going to any Target, please. Do you have the ability to hire a lawyer, ma'am? Would you like to apply for a court-appointed lawyer, or what would you like to do? Okay, I'll have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box while we'll get your bond conditions. We'll have you sign it, and after that, you'll be free to go. We'll get your bond conditions. We'll have you sign it, and after that, you'll be free to go. You are Erica Vasquez.
Yes, hello, sir.
Ms. Vasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 23rd, 2025, officers were dispatched to the 23,900 block of FM 529 Road in reference to a major accident. The officer made contact with the paramedics who were providing care to the defendant and stated that the defendant required transport to the hospital due to complaints of pain and high blood sugar levels. The witness stated he observed the defendant still sitting behind the wheel of the vehicle when he pulled over to assist her after seeing the vehicle stuck in the ditch. The defendant stated she failed to maintain a single lane, which caused the vehicle to go off the roadway and enter a ditch filled with water. The defendant admitted to drinking 2 bottles of Smirnoff and was observed to have red glossy eyes and the odor of alcohol on her breath. The defendant was transported to the hospital. The officer observed an open 24-ounce twisted tea can, which was cold to the touch in the center console.
So drinking while driving?
Yes, Judge. SFSTs could not be conducted. The blood warrant was signed and executed.
Valid Texas license? Ms. Vasquez, I'm going to find that there's enough probable cause to go forward with your case. I am now taking away your privilege to drive. You are not allowed to drive for any reason. Do you understand? If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what your reason is. There's no justification you could give for getting in the car and driving. Do you understand?
He does have an eligible driver's license.
Yeah, we've had a phone call on it. Any prior DWIs?
No prior DWI, Judge.
This is the affidavit that you're going to be signing with me. This is a court order that you promise you're not going to drive. Do you understand, Ms. Vasquez? I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. No more PR bonds. Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer, ma'am?
I have a lawyer. I have a lawyer.
You already have a lawyer.
Yes.
You have, you hired one, or you're going to
Yeah,
go?
I hired one already.
Oh, Judge, open order, I guess it just signed on.
So what we'll do is we'll just have you take us, well, first now, I'm going to have you come up, swear to us that you're not going to drive, and we'll get you to Victoria, sign and reset. You will get with Felicia for your bond conditions, and then we'll just have you wait.
Yes, Judge.
Hey,
Good morning, how are you?
hey, what's new?
I have an off docket, is that okay?
No problem.
Okay. The cause,
Flynn on the docket this morning for arraignment.
Okay, you ready?
Yeah, Mr. Flynn.
Good morning, Mr. Finn. Sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 22nd, 2025, at approximately 11:07 p.m., an officer was dispatched to 59 Northeast Cross Timbers on City Street. The officer observed a vehicle run a red light, take the exit, swerving in and out of lane number 2 and cross 3 lanes of traffic, almost striking a guardrail. A traffic stop was initiated. The officer observed the driver to have bloodshot eyes, slurred speech, and the strong odor of alcohol upon his breath. The officer had the driver and the passenger exit the motor vehicle. The driver consented to SFSTs and the defendant performed them. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The defendant was read the DIC and consented to provide a breath specimen. The results were 0.141 and 0.138. The defendant advised he had 1 drink while at a bar, and he was the owner of the vehicle, and he was identified by his Texas driver's license.
Any prior DWIs?
No prior DWI, Judge.
Valid license?
Valid license.
All right, Mr. Finn, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Just keep my city safe. That's all I want. You understand?
Yes, sir.
I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go.
Thank you, Your Honor.
right this way.
Jones, you wanted us to come to docket today.
and he's here.
I'd like to send him for a drug test, alcohol test. I want to make sure he's not using though.
If that's the court's prerogative, that's fine. However, he is checking into the Menninger Clinic tomorrow after his rehab from Ohio.
How long has he been?
And I'll be very frank with you, the last time I was here with him, he looks like $1 million compared to the last time I saw him. And I've been speaking with him very frequently on the phone. I'm more than happy for you to talk to him, Judge, frankly.
Come up, sir. The last name is, this is Jones. We're here because Mr. Jones doesn't have his interlock that he was required to, and he's been in lockout for quite some time,
Correct.
which is unacceptable. Right? If you're in rehab, we have to know, and there are certain measures that we can take, but just if you don't tell us anything and you're just in lockout, that's a problem. I have a real big problem, and I don't know you. Everybody tells me it's little raindrops and gumdrops and little bunnies jumping in the woods, but how the hell do I know? So he's telling me that you've been in a rehab in Ohio.
Sir.
When?
The last setting that we were here, the prior
Okay.
setting to this, Judge, he got on a plane from the courtroom and went off to Ohio. And I actually forwarded the court his admission paperwork to that facility in Ohio.
What was the date of release from that program?
It was last Friday. I spent 8 days in the hospital detoxing, and then the rest of the time in the rehab. And, I'm trying to put together a forward plan. I'm not supposed to be talking too much, but to take aftercare and go back to another rehab here locally and work on getting better. And I'm being proactive with that, Your Honor.
He's had to change insurance.
That's all we ask, because the problem is that some people can, and some people can't,
Sure.
Addiction, it's a lifelong, and it's a persistent monkey that's on your back that will never let go. It will constantly grab at you. So if you're not proactive about it, that's when it grabs you by the boo-boo, and it just doesn't go well.
Sir.
I just need to make sure that you're not using, number one. Number two, most importantly, that my public is safe, because I certainly don't want you in a car unless, everyone is protected. And the way we know that is that you don't have alcohol on board. So what I'm going to do now, because you've been so AWOL with regard to this, I'm now putting a monitor on your ankle so I know that you're not consuming. If it goes in lockout again,
Warnings. No more pauses. This is the judge laying down the law. Mess up again, even once, and it's straight to jail. Rehab or not, the patience is gone.
I will put you in jail. I want you to know that. I'm not going to do this again with you. Do you understand? You've been in lockout for a significant amount of time, and it's not fair, because I normally would put people in jail lickety-split for something like this. Do you understand?
Sure.
I will not play this game with you again. It is your responsibility to charge it on a daily basis. It is your responsibility to know what you are putting in your body, as far as, whether it be mouthwash, hair dye, a tequila lollipop. I've heard it all, and I don't care for excuses. It is your responsibility to know. You've got such a great team of lawyers. There's just no excuse.
Sure.
I will waive the fee so that there's no excuse for, well, I can't pay for this. I can't. No. Do you understand?
Your Honor.
What you do on your time is you. As long as I know that you're not using, I'm happy. Do you understand?
Yes, sir.
Okay.
I'll be happy once he checks into the manager point. You alert the DAs, the court. everybody
Yeah, I guess,
there.
well, we're going to give him the scram device today. Just keep us in the loop as far as, the cases are too terribly old. It's not old. So just keep us in the loop of when he's released. Just, you have to calibrate this thing on, I think it's monthly. So make sure that you calibrate this thing like it's supposed to. They have to download it. You've got to charge it. So make sure you know of everything you can and can't do. You understand, Mr. Jones?
Yes, sir.
If I have you come up here on another violation, it's probably not going to go well, just so you know. Okay? Okay, guys.
Understood. Thank you.
Can he
Got it.
be released from the jury box? Just take a seat. We'll get you. She's gonna have to talk to her. You know, she's already ready.